Thank you for clicking this video. This is Batok with Ola. My name is Mujola Oluwa, and today I want to talk about witness preparation. Witness preparation is very important for litigation lawyers because it can make or mar your case. You know that trial dates are very or can be very elusive, especially in Nigeria, due to several factors which I have mentioned time and again on this channel. We could talk about how you could get to court and the court would not sit, or the opposing counsel might not come, or they might say they are not ready. Anything can literally happen. So it's very important, if you get a trial date, to put your best foot forward and make sure that you make the most of it, because if you miss it and you have to get an adjournment, you might not get one that easily again. So very important. And one of the ways to make sure that you make the most of a trial date is by getting your witnesses ready. Witness preparation is not the same thing as how would I say it, teaching your witness what to say, or helping your witness master how to lie on oath or on the stands. No, witness preparation includes a lot of things, entails a lot of things, and we're going to be talking about it in this video. And the way that I want to talk about it is to use the WH questions. So we're going to be talking about the how, the why, the when, the where, and the what. So let's start with what. What is witness preparation? Witness preparation is the process that you take your witness through to get them prepared and ready to give their testimony in court on a trial date. It's important to prepare your witness so that they do not mess up the case, so that they get their facts straight. You're not just prepping them for what they will say to the court, you're also prepping them for how they would say it, how it would come off to the court, just to ensure that your own goal for your matter is achieved. Because as a litigation lawyer, you must have a goal. What do you want to achieve with this matter? What do you want to achieve with this witness? Why are you listing this witness as part of your witnesses in the case? So you must make sure that you prep them in such a way that that goal is achieved. So that's the what. The why. Why witness prep? Witness prep is important because the witness can make or mar your case if not well prepped. So it's important to prep your witness to help them get their story straight, to make sure that they are not saying more than they should or less than they should, to make sure that they exude confidence where they should and exude timidity, yes, sometimes when they should, because the court will be looking at the demeanor of your witness aside what they are saying as well. Witness prep is important to make sure that the opposing counsel does not elicit information from your own witness that can destroy your case, because they will try to do that. And even if you are also cross-examining another person's witness, that's what you'll be trying to do under cross-examination. So you must prep your witness to make sure that they do not destroy your case, one, and they do not help the other party, the other counsel, to destroy your case. So very important. So that's the why. Then the who. Who preps a witness? The trial lawyer should prep the witness, if possible, and if not, a paralegal that will probably be there on the court date, the trial date, should also prep the witness. Aside that, any lawyer can prep the witness who is well abreast of the matter in the of the facts of the case and how the case is progressing. Very important. But if you're going to put the witness on the stands and ask the questions on the trial date, it's important that as much as you can be the one to prep the witness. So other people can prep the witness up beforehand, but last minute prep you should be the one to do it. So that is the who. Then when should you prep your witness? You should prep your witness way ahead of the trial date. So you should have a session where they come to your office, preferably, and then you go over the case with them. You ask them questions, likely questions that you would ask, and you also ask likely questions that the opposing counsel might ask, what the court's disposition might be to some answers or to some questions, how they should look, what they should wear, when they should arrive, and what they should say, how they should say it, how long or how lengthy or how brief, their answers should be, their demeanor, how they should look, where they should face, who they should look at, when they're answering questions. All of those things you need to go over it with them. So preferably maybe 2 weeks or a week to trial date, you prep your witness. Then on the trial morning, you can re-prep them, briefly if you have the time. It's very important. So I had a case once where I wasn't going to court because I was otherwise engaged. But what I did was I prepped the witness for the counsel that was representing me in court in the matter. Then I drafted a list of likely questions and the answers and sent it to the witness and to the counsel as well, so that we'll all be on the same page. And it went really well. So that's something that you might try to do. In some instances, if you're a paralegal or a junior or a younger lawyer and you're attached to a senior lawyer who is going to do the matter, he or she might prep the witness ahead of time, but the last minute prep might be left to you. It's important for you to read the file from cover to cover, know what it is about, know where you're headed, where your senior is headed as a young lawyer, so that you know the kind of questions that you prep the witness with and the kind of things that you tell the witness to do or not to do. Understands very important. So we've talked about when, why, who, where you should prep your witness in your law firm, if possible. Then on the last date, on the trial date, you can re-prep them within the court premises, outside of the court room, of course. Then how should you prep your witness? This is the most important part. So let's say that you're prepping your witness is already in your firm, your chambers, or before you even on the trial date, outside of the courtroom. You should first, what you should most likely do, what I do sometimes, what I've done, is that I would ask the witness your name, how you're connected to this matter. You can ask that, and then you look for their own statement. If it's a witness that has a statement already in the file, you look for their statement, and then you ask them what they know about the matter. Let them tell you offhand, without consulting the statement, what they know about the matter or what they have come prepared to tell the court. So after you've gotten that from them, you would be able to start to say that, oh, you can't say this, you should say this, have you forgotten this, why didn't you add this? Then you look at their statement and tell them, in your statement you said this, but you did not tell that to me now. So you should say this, you shouldn't say this. So you go over it with them. After that, you can start to ask likely questions. Okay, let's practice. It's my principal that's going to ask you questions. If you're a young lawyer, that's the example I'm going with now. But let me ask you now as if I'm the one that will ask you. But I'm not the one that will ask you in the courtroom. I've done that before. So answer the question. So what is your name? Witness, tell this honorable court your name, where you live, and what you do for a living. Those first three questions should be sorted already. The judge or the court should not start having problems with the witness from get-go. So get those ones out of the way. This is your name. In case they have a different name or a multitude of names, tell them this is what is on your statement. So this is the name you're giving to the court. This is what you do for a living according to your statement, and this is where you live according to your statement. So tell the court these things. Then make sure you face the court. Do not face me, do not face the other counsel, even if I'm the one asking the questions, if the other counsel is objecting or anything. And during cross-examination, even if the other counsel is asking you any questions, whether they're being nice or being nasty, make sure you face the court, the judge, because that is the person that is putting down what you're saying. So very important. Then their demeanor. If it's a witness that you need to look very sober and remorseful, for their case, you make sure you get that straight with them. So if it's a witness that you need to exude a lot of confidence and mini pride, you let them know that, and so that they prepare to do that. So you also try to get the personality of the witness. That is why it's important to prep them ahead of the court date, so that on the court date on the trial date it will just be like a re-prepping. So what kind of witness is this person? Do they talk too much? You must caution them. You cannot say this before the court. You cannot continue to explain. Make sure you don't explain too much. Tell the court only what is necessary, only the answers. So you can give them some answers, suggest some answers. For instance, if you're asked, how many children do you have? Just tell the court you have 2 children. There's no need for you to start saying, oh, you had 4 and then 1 died, and then you found out that one, you were not the father by DNA, and now you have 2. No. How many children do you have? 2. Go straight to the point. So then that's an example. So if it's a witness that needs to explain as well, we tell them to explain. So it's important for you to help your witness to help your case. An unprepped witness is a disaster waiting to happen. An unprepped witness is a nightmare waiting to become a reality. You cannot afford it. So do not let it happen. Even if you, as the lawyer in charge of the case, do not have the time, let your paralegal or assistant or junior lawyer do some prepping ahead of time, so that you can do the last minute prepping if time permits. So very important. So after you've asked the witness likely questions, you can ask them to ask you some questions or tell you some things that they would like, or they are likely to tell the court that you have not been through or gone over with them. So if they tell you, but I want to say this also happened, you let them know, okay, you can say it, or okay, you can't say it because if you say it, it will open a can of worms, or this is why you shouldn't say it. So you cannot treat your witness like a robot. Let them know why they can or cannot say some things, so that the reason, the rationale, they will remember it, so that they will remember that reason or rationale, when they are tempted on the stands to say those things or to do those things. This is why you cannot do this. This is why you cannot answer in this manner. And then you go through cross-examination with them as well. So likely questions that the other counsel might ask you. I do that a lot. So they might ask you, if you say that you live at so, they might ask you, so why are you claiming an alibi for this particular place on this particular date? Is it not too far from your house? Then you explain to them that you always stop here on your way from work and blah, blah, blah. So you go over likely questions from the opposing counsel as well and how they should answer. So you should also say to them things like, oh, if they say this, please do not answer. If they say this, even if they say this, do not allow yourself to be riled up to the point of anger or to the point where you start to give off unnecessary information. Where did you depose to their affidavit? Tell the court where you did, and all those things, that the questions that will be asked. So you tell them. So you address the court as my lord or your lordship. You tell them that too, because it might be a witness that has never been to court or has never been in court. So you let them know. If it's also an expert witness, you might also let them know that although you're an expert witness, do not go on lecturing the court about some jargon that are peculiar to your field, or you can let them know that speak in plain language or speak some jargon and give an explanation. So depending on who your witness is, you lead them, you prep them accordingly. I once had a DSS witness that had never been on the stands. He was a young officer, so I had to prep him about 3 times. When my senior came, she said, prep him again. Then I gave him to my senior, and my senior also prepped him because he had never been on the stands, and he wanted to actually be prepped and prepped over again so that he'll do well. So I think how I started was, I said, what's your involvement what's your name? Then I looked at the statement. So what did you do in this matter? Then I gave him the statements to read. For police officers, law enforcement agents, and they usually want to read their statements again, because between the time when they made the arrest or conducted investigation and the time the case is coming up for trial, sometimes it could have been months or even years. It's important. Let them have that statement. Let them read what they said they did in the matter. Let them familiarize themselves afresh with the names mentioned, the places they went to, the things that they put down, maybe the items that they recovered from the scene of crime, and all those things. So, in fact, sometimes they ask for the case file, the original case file that's in the file. If it's a criminal matter, give it to them. You could give it to them before the trial date or even that trial morning. They have a way of quickly going through it and familiarizing themselves with the content. So the important thing is, do not blindside your witness. Your witness is on your side. You are a team, so they must be working for you, and you must make them work for you by prepping them. So I think we've covered the basis, the how, the why, the when, the who, the what. So also put your witness at ease, especially if it's someone that has never been to court. Help them to be at ease on the stand. So you tell them that if you're feeling weak, you can ask the court, for permission to sit. The court will get you a chair, and you can also do that for them, during trial. Ask the court for a seat for them. In fact, some judges on their own volition would ask their clerk or registrar to get the witness a seat, especially if they've been standing for long, or if it's an older witness or a witness that has some form of illness. Very important. So tell them to relax, to choose their words carefully, to answer only what needs to be answered, not to get riled up by the opposing counsel, not to look at you or to act too familiar with you on the stands, because it might do a great disservice to your case. So, and then they are to dress well, dress properly, not over the board, but at least to portray who they say they are, or to portray something different from what they are being accused of, if it's a witness that is being accused of something, of course. So very important. Also, it's important not to train your witness to lie. as much as possible. Do not train your witness to lie, because lies can boomerang. Your witness could forget the script and they could get out of character. So what's the point? Get only the witnesses that are useful to your case. Get them, prep them to come and say the right things and to carry themselves in the right manner before the court, and you're home and dry with your case, whether civil or criminal litigation. That's all I want to talk to you about in this video. I will see you in my very next video. Don't forget to subscribe, and if you have any questions or if you need personal consultation, check the link in the description box so that you can book a consultation, or shoot me a mail at houseoflivingstones@gmail.com. Don't forget that if you're mailing me because from Batok with Ola, please put Batok with Ola as your heading in the mail so that I can easily identify and separate it from other business mails. Thank you so much. Bye for now. Toodles.